I've received a number of phone calls from people that are potential clients, those that have become clients, where they have already been sentenced or they're getting ready to surrender and they know nothing about the the allocution or where they're going to surrender to or how many prisons should they make a recommendation to the judge to go to or what is their personal narrative or even they have just pled or been found guilty and their pre-sentence interview is 7 days away. I mean, it's crazy stuff. Hello, my name is Mark Blatstein, physician founder of Physician Pre-Sentence Report Service, where we provide white collar sentence mitigation solutions. And so this really motivated me because I've had one too many of these same phone calls where if you've been either you went to trial and by all rights, if you're going to go to trial, it's okay. Um, it's a free country. Your attorney hopefully has let you know that you have less than a 2% chance of being acquitted at trial. But as long as you're prepared and you feel that you're in the right and you have documentation and you and your attorneys on the same page, then definitely you don't want to anger the court. But going into this with your eyes open, if you lose, you need to be able to go back to the same judge for leniency, which is why you want to be respectful throughout this entire trial. But at the guilty stage, be it by plea or by trial, you want at least 3 months, 90 days. You don't want to turn around and 7 days later have to have your pre-sentence interview or the pre-sentence investigation. I mean, that's just nuts. For no other reason that the probation officer who conducts your interview is going to want a lot of information from you. They're going to want tax information. They're going to want just a voluminous amount of documentation. If you're educated, you want copies of all your records from either to show that you have finished high school or college or postgraduate work. Going back to the tax information, proof of your income. They may know a lot of this already, but you're going to have to, begin gathering all that information. If you're a little bit older or if you have medical problems, hospitals and doctors' offices are not going to drop what they're doing just to give you get that information to you. If you're on medications, they're not going to just stop what they're doing and review all the drugs that are available on the Federal Bureau of Prisons website to make sure that the medications you're on are covered by the Federal Bureau of Prisons. They just can't do that. And so you need to allow time for for personal family issues to be able to be resolved. For if you have a business, those issues to be resolved. If you have medical issues, for those issues to be resolved. You need 3 months in addition to being able to be prepared because you're going to have to hopefully be prepared to have a conversation with your judge. And so your attorneys are there. They're there to provide you through the legal process. They're lawyers. They're trained in the lawyer component, in the legal speak, if you would, if you will. They advocate for your defense. But once you get that indictment, is when you decide, with your attorney, what are you going to do? Because the indictment is not going to, you're not going to sound all that flattering. And so you need to decide, in addition to all of the legal arguments that your attorney is going to make, it would be helpful if you'd also begin preparing your background information, which is called your story or your personal narrative, so that your attorney knows a little bit more about who you are and what brought you to this point to commit this crime, if you will. It's a little more involved in that, but this personal narrative is important because if you don't do that, and before you get sentenced, your first visit is going to be with the probation officer who's going to conduct a pre-sentence interview. And if you do not go out of your way to provide all the information that they want, spell checked, collated in an organized manner, and have your story, your autobiography, where you accept responsibility for what you've done, have remorse for the victims harmed. I know I'm going through this quickly, and have some sort of release plan put together in paper. This takes time to write out. But if you have all of that done and then provided to the probation officer, because about 7 to 10 days before you have your pre-sentence interview, that probation officer is probably going to feel that you've taken this responsibility and this interview seriously. And that person's the most important person that you're going to meet because they make recommendations to your judge regarding the length of your sentence. So I would think that that's a very important meeting that you're going to have. And if you do nothing, then your judge is going to be left to sentence you based solely on your indictment, which is probably not that flattering, your pre-sentence report, which that officer is going to write based on that, your indictment, which is not that flattering. So this won't be either. And that's going to be essentially the four corners of your indictment. And so you won't have anything going on in your favor, and your judge will be left to sentence you knowing nothing about you because you didn't make any effort to explain your story, your history, your narrative of who you are to the probation officer before you met with them at your pre-sentence interview. Now, going forward, and they usually, your attorneys don't have the time to understand who you truly are. Plus, they could be charging you several hundred to several $1,000s an hour. I'd love to work with you, or at least find someone like myself to do this type of work. This is what I do. I mean, I happen to have I'm a physician, so I've done this all my life. But you need to have someone be able to work with you to explore your past experiences and how they've influenced the choices that you've made. No excuses, but this is important because your judge is going to want to hear from you. And these nuances of your personal background are just not part of a traditional legal defense. And this is just not me stating this. Your personal narrative that I referenced, your release plan, this is very important. This is what judges want to hear, especially because if you write your personal narrative, it should have answers to all. It should cover all the information that your probation officer needs to fill out their pre-sentence report worksheet, which turns into your pre-sentence report. And in doing that, your judge then is going to read that, and this may be a driver for them that then talk to you during the sentencing hearing, and you have the chance to influence your judge to possibly reduce your sentence. And so it's important. And it's surprising, as federal judge Patrick Schultz has been quoted as saying that a lot of competent attorneys wait at the last minute to punt at sentencing hearing. Here he's referring to sentencing memorandum. And some attorneys rather, will go out of their way to, as part of their sentencing memorandum, to speak up for their client, the defendant, for you. That's not, the judges understand that attorneys are paid to say nice things about you. They don't want to hear that. They want to hear your story in your hand, written by you. And from federal judge Mark Bennett, he's been interviewed both in print and on YouTube, by saying that he would much rather hear that from you, the client or defendant, than in any other way. He's never heard of that before, but he's in firm agreement. And so you don't want to wait until the very end to think about sentencing advocacy, as another Judge Robert Scalia has been quoted saying, because, as I again referenced earlier, 99% of those indicted wind up going to prison. And so as you begin to draft your personal narrative, you begin to own it and understand it's a cathartic experience for you. It may be difficult for some. It wasn't easy for me. And I didn't have this kind of knowledge. I too had a felony. And while back in 2006, I had the felony, I was able to get my medical license reinstated. And so it's important because as the judge reads your pre-sentence report and reads your narrative, your personal narrative, this may give them the opportunity to speak with you. And you're able to talk with them, which is your allocution. There's no guarantees here, but I've had clients when they speak with their judge where the sentence is reduced almost 50%. I've read online where those that have been incarcerated for a long time with life sentences, a little different than this, but it's by actions that you take. This person had a life sentence, and just by the amount of work he did to educate himself and to mentor others in prison, by the time we connected, he was on his way to home confinement. This is from a life sentence. And so I hope you take this to heart. If you feel that I could be of service to you, or that if you have any questions, please do not hesitate to give me a call, Dr. Blatstein or Dr. Mark, 240-888-7778. And thank you very much for taking the time to listen to this video. I hope you have a good day.